Oyez, oyez, oyez. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and ye shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Good morning. I'd like to welcome everyone to this new term of court. I want to acknowledge the operation of the Supreme Court of Arkansas for 185 years as we begin this new term, since the fall of 1836. And we as the current justices hope to carry on that proud tradition that's been established by the court over the years. Our case for oral argument this morning involves actually two cases with the same appellant, Timothy Wayne Kemp versus State of Arkansas. One case is CR-95-549. The second case is CR-98-465. And the court will recognize the appellant's attorney at this time for their argument. Ms. Vandiver.
Thank you. Good morning, Mr. Chief Justice, Associate Justices, and may it please the court. The only eyewitness to testify against Timothy Kemp, Becky Mahoney, was asked 9 times at trial and resentencing whether she saw a gun at the trailer that night. And 9 times she lied and said she did not. The prosecutor sat silently and allowed the lie to go uncorrected. Tim Kemp told the police and argued at trial that Wayne Helton and others had threatened him, but he had no corroboration that he had been threatened. But the prosecutor did. She took down in her own hand. Wayne showed Becky a pistol that he had and said he would use it to scare Tim. The prosecutor knew that when Mahoney said, "I never did see no gun," that it was a lie, and yet she said nothing. This note was hidden in the prosecutor's file for 19 years. The defense didn't have it when the prosecution argued that Kemp slaughtered 4 unsuspecting victims with no opportunity to defend themselves. The defense didn't have it when the prosecution argued there was no evidence that he was acting in self-defense.
But Counselor, didn't in fact the jury understand, wasn't evidence presented that a pistol was found next to the bodies in the trailer?
Yes, Your Honor, there was a pistol found next to the bodies, but the very difference between a pistol being there and one of the decedents having a plan to threaten Mr. Kemp with a pistol are 2 very different things. The prosecution also exploited the absence of this evidence at the penalty phase by arguing that Kemp's claim that he was threatened was a lie that showed he had no remorse for the lives that he'd taken. And this is why the writ of error quorum nobis exists. The juries that convicted Tim Kemp and sentenced him to death did not know the true story. And the court should reinvest the circuit court with jurisdiction to determine whether, had these facts been known at the time, the result of the trial and the resentencing would be known. This court has touched on issues of false testimony in the context of a Brady claim before in Wallace and Chapman, and Mr. Kemp's claim meets all 3 of the standards of a false testimony claim. The first is, was there a material inconsistency? There is no doubt. Mahoney told the prosecutor before trial that she saw Helton with a gun. Yet at trial, she denied seeing a gun. The falsehood was known by the prosecutor. That is undisputed. That note was the prosecutor's own note. And was the inconsistency sufficient to alter the trial? And Justice Hudson, I think that this gets to your question. The defense was trying to prove that Mr. Kemp was threatened with a gun, and the state was trying to prove that he wasn't. And this evidence undercuts the prosecution and supports Mr. Kemp's claim in really three big ways. The first and the most
is that, I mean, we have an element of prejudice that is critical to this analysis. And when you have Mr. Kemp presenting at the trailer after leaving to retrieve a gun, knocks on the door with a weapon, the jury is aware of that, and the jury is aware that there is a pistol found inside the trailer next to the bodies. So we're looking for an element of prejudice here in order to grant relief on behalf of Mr. Kemp. And what I'm seeing is that the jury does have a fulsome picture from the perspective of Kemp presented at the trailer with a weapon, and the jury knew that there was a weapon laying next to the bodies in the trailer.
I disagree, Your Honor. And the reason that this evidence is important, not just because Helton had a threatening mindset, but because it is important on the issue of timing. The prosecution's theory at trial was that Kemp left, went home, got his rifle, and then knocked on the door and caught these people unawares. What this note shows is that in Mr. Kemp's absence, and we don't dispute that he left, he told Terry Ward that he just drove around the block. Either way, we don't dispute that he did leave the trailer, but he says that it was when he returned is when these threats started up outside the trailer, that when he got back, they were standing around the trailer and threatened him, threatened to kill him, threatened to take his truck, leave him for dead. And this note and Wayne's plan supports Mr. Kemp's version of events because it says that Wayne was planning a confrontation for when Mr. Kemp returned. He did not sneak up on these people. He did not catch them unaware. They were waiting for him to come back and planned an armed confrontation for when he returned. And that is exactly what happened when he got back. And the jury could have believed that Helton carried through with his plan. And you're right, there was a gun there, and that is a very important piece of evidence made much more consequential by this evidence that Helton planned to use the gun to scare Tim. So if this evidence, if this testimony from Mahoney had been in evidence, is a jury more likely to believe Kemp's version of events? I came back and was scared with a gun. They put me in fear for my life. Yes, the answer has to be yes. And
Counselor, Mr. Kemp came to the door armed, knocked on the door, and it was Becky Mahoney's testimony that it was only after the knock on the door that she heard gunshots.
That was the testimony at trial, and I think that this evidence undercuts it. And we could prove at a hearing that there is another version of events that is more credible with this new evidence as part of it. And another important part of this evidence going to Becky Mahoney is that it's not just exculpatory, but it does impeach Mahoney. Why is she telling a different story regarding this crucial fact in private to the prosecutor than she's telling the jury? So this cast doubt on her veracity as a witness onto many points, and one of them is whether or not Mr. Kemp knocked on the door and unloaded his gun, or whether the conflict started outside of the trailer as he told Terry Ward in the morning hours after this.
Counselor, don't you think that it is possible that Ms. Mahoney's veracity was already in question by the jury when the jury hears her testimony about there being no gun and then sees evidence of a pistol found in the trailer?
I don't think so. I mean, not necessarily. They could have believed that it wasn't in play in the events before, before the shooting. And so it's very important whether or not this pistol was being used by Helton. And she could have told the jury could have believed that Helton, one, had a threatening mindset. He meant to put Kemp in fear for his life, which goes toward the whole atmosphere that was at that trailer. The prosecutor tried to argue throughout the trial that Kemp was reacting to a simple fight with his girlfriend. And this evidence shows that he was reacting to what is very likely a threat by an armed person. And that even if you were to find that we can't establish prejudice at the guilt phase, which I certainly do not concede, I think that the circuit court could find that a jury would have a reasonable doubt as to the premeditation element of capital murder. But certainly it goes to prejudice at the penalty phase. The jurors could have believed that Mr. Kemp was committed this crime under an emotional disturbance, or because he believed he was acting in self-defense. Those were two mitigating circumstances that were offered to the jury. Some jurors, but not all, found those mitigating circumstances at the first trial. No jurors found that at the resentencing. And it is very likely either that more or all of the jurors would have found those circumstances, and that they would have made a different calculus as to the weighing of the mitigating circumstances versus the aggravators.
Counselor, would you please address the state's concerns about the lack of due diligence on Mr. Kemp's part? As you know, Mr. Kemp became aware of the allegations that you are bringing to our attention today back in 2013. However, he chose to wait 7 years before bringing those in terms of a state claim. Rather, he was the time it was languishing over in federal court with federal proceedings, and I suspect that you are going to say that we should excuse a lack of due diligence because he was engaged in federal habeas proceedings.
I would take issue with the phrases waiting and languishing. He was diligently pursuing relief on his claims. In the Newman case, the court held that what is important is upon discovering the underlying facts of the claim, that petitioner's counsel begins pursuing relief. And Mr. Kemp, when he discovered this information, he was in federal court, and he discovered it only with the assistance of a federal subpoena. And he had already been back in state court on a stay of his federal proceedings. And all throughout that time, the state was suppressing this information. So his opportunity to present these claims in the state court was thwarted by state suppression. So the state has argued that that this is a case like Eccles or Roberts, where the court can find as a matter of law that Mr. Kemp was not diligent, but it's not. Like in Mr. Newman's case, he discovered the claim in federal court. And when he raised the claim in federal court, the state said there were no available state court remedies. And for them to now say, like they did in Newman, which this court roundly rejected, that we should have been pursuing those remedies, and that makes this dilatory, is not fair, and it's not required by this court's jurisprudence. And
Counselor, wouldn't you agree that Newman is distinguishable? Mr. Newman had meritorious claims of incompetency. And if you will recall, throughout the litigation, Mr. Newman was completely uncooperative with counsel in advancing his interests, certainly on appeal. Mr. Newman wanted to die. He didn't want counsel. He wanted to represent himself. It seems to me that we have a very different situation here with Mr. Kemp. The facts are different, but there's no legal significance to the difference. In the court held in Newman that Mr. Newman's incompetency thwarted presenting his claims in Rule 37. The state's ongoing suppression of this information prevented Mr. Kemp from presenting this information either, at any earlier time. And so it is
indistinguishable in any legal sense, other than the fact that, I mean, it's Mr. Kemp's not raising an incompetency claim. And Mr. Newman, as I'm sure you recall, also did raise Brady claims that were at issue in his case as well.
But as I recall here, Mr. Kemp, after being dismissed from federal court, rather than coming back to address the state claims, he went on to appeal the federal decision rather than coming here. And then all of a sudden we wake up and it's 7 years later.
The federal district court is not a court of last resort. It's the trial court. I mean, I'm sure you know, I'm not trying to tell you that, but it's not a court of last resort. And so Mr. Kemp appealed that procedural ruling to the 8th Circuit and to the Supreme Court. And this is a death penalty case. And so Mr. Kemp is entitled to do that and should do that. And for him to instead come to this court would have risked federal review of those claims, because he would have created an exhaustion problem where the court had already conceded that his claims had been exhausted. I see I'm almost to my rebuttal time, so if there's no further questions, I think I'll reserve the remainder of my time.
Okay, thank you. Court will now recognize the respondent. Mr. Holt. Need to unmute.
Thank you, Mr. Chief Justice and members of the court. May it please the court, my name is Kent Holt and I represent the respondent, the state of Arkansas in this case. Mr. Kemp's application should be denied for 2 reasons. First, Mr. Kemp was not diligent under this court's quorum nobis authorities by not bringing his application when he discovered the claims in 2013. There is no dispute that Kemp's claims are either part of his rejected 2010 application to this court or the claims that he discovered in 2013 and instead of coming to this court added to his federal habeas petition, circumventing this court's prompt consideration of his new information, which is at the crux of this court's diligence requirement. Second, in the words of Judge Price Marshall, the federal district judge who conducted federal habeas review of Mr. Kemp's claims, all these claims wouldn't have made any difference to the outcome of the case in either the guilt or the sentencing phase. That is an easy conclusion to reach, and this court reached it actually in 2002 because it observed that Mr. Kemp, by any version that he gave, left, armed himself, returned, and shot everyone he could find. If I could, I'd like to first discuss diligence. I believe the question should be this: what prevented Mr. Kemp from bringing a second petition in 2013? The answer is nothing.
Well, Mr. Holt, what opposing counsel just said was that he could have put his federal claim in jeopardy. Can you speak to that?
I would strongly disagree with that, Your Honor, because state courts are the principal forum for asserting constitutional challenges to state convictions, not federal habeas review. Federal habeas review is secondary. And if he were, there is a Justice Breyer of the U.S. Supreme Court in Cullen v. Penholster noted that Mr. Penholster could always go back to state court if there were additional facts that he had that he wanted to be considered, because federal courts are not generally, all of the rules of federal habeas since 1996 are designed to channel the fact finding to the state court. And that's exactly what the federal court did here. And Mr. Kemp was aware of that in September of 2014 because he told the federal court, I believe that's Exhibit 4 that we've appended to our initial response. He told him that he had an available state remedy, and that state remedy was outside of the scope of regular review, but it's called a petition for error coram nobis. And Mr. Kemp also told the federal court that he didn't have to pursue that in order to exhaust his remedies. So he knew that he had this extraordinary remedy that he could seek at any time. And yet what he did was he chose to take his chances with a second amended petition. He could have taken the claims that were claimed for in that 256-page second amended petition and put a style on it, Timothy Kemp versus State of Arkansas, second application to reinvest jurisdiction in the circuit court.
Well, Mr. Kemp simply made a different legal kind of a strategic choice. He chose to,
Exactly.
as opposing counsel said, move towards a court of last resort. The federal district court is not that. And that was his choice. So it wasn't necessarily languishing, as Ms. Vandiver suggests. It wasn't languishing. They were doing something. It's just they weren't doing it in state court. And in Newman, we said that was excusable. So how is this different?
Well, the key to this court's diligence requirement is linked on discovery. It's not whether you look busy in some forum other than the state court that this court. Mr. Newman was thwarted, as you mentioned earlier. He thwarted counsel in state court. Counsel was they were pursuing relief in federal court and discovered that there were additional facts. Now, Mr. Newman resisted going back to state court. But the state court the federal district court determined that those were significant enough that it would stay its proceedings. But whether or not there's a stay, Mr. Kemp was able to go back and to develop facts because he wasn't getting a hearing on this in federal court because he had already been in federal court 2 years. He had been in state court for 5 years. If there was any languishing, it would have occurred in the first 7 years after he filed his federal habeas petition. But nevertheless, what Kemp is trying to do now is to circle back. And it's an attempt to circumvent the policy that the federal habeas rules and the rules of this court are meant to enforce. And that is that this court is the principal forum for constitutional challenges to state court convictions.
Well, Mr. Holt, as you are well aware, this is a death case. And would it be prudent for the court to make a decision based on lack of due diligence when we know, and this court has said often, that death is different? Should due diligence really be held to such a high standard when the court could choose to address the merits of Mr. Kemp's allegations and arguments?
Well, Your Honor, because Mr. Kemp has not followed this court's rules, he matches the description that was described in Rines v. Weber, where the U.S. Supreme Court said that not all petitioners have an incentive to obtain federal relief, or for that matter, state relief, in a speedy manner. And that is the case here. What Mr. Kemp has done is he has tried to circle back to the court that is actually the primary decider of this issue because it's a state court conviction. But he didn't like the answer that he got in federal district court. So he's decided to circle back and circumvent the policy that this court, as recognized by the U.S. Supreme Court, that the whole principle of federalism is that this court is the primary forum for determining the validity of state court convictions. We believe you, Justice Baker, got it right in Roberts, also another death penalty case, where Roberts' counsel acknowledged the facts of their claim were discovered in 2008. And in your concurrence, you simply pointed out that they waited over 4 years to file a petition with this court. This court's requirement is that after discovering the fact, the petitioner doesn't delay in bringing the petition. If I could, I would move on to the second point, in that these claims as they were found by the federal district court wouldn't have made any difference. We believe that this court would, if this court had had the opportunity to examine these claims in 2013, when Mr. Kemp discovered them, that it would have reached the same result Judge Marshall recognized as the central fact of this case, and one that's obscured by Mr. Kemp. There was no rational basis in the evidence to support giving the instruction of imperfect self-defense, because it does not apply, quote, when one arms himself and goes to a place in anticipation that another will attack him. By any version that Mr. Kemp gave, he was the aggressor in this case, not Mr. Helton, who very well may have said what Rebecca Mahoney told Melody Piazza that he said. However, by that time, and by Mr. Kemp's version, he had already said, hell, I pulled my gun out. All Mr. Kemp really had to rely on for self-defense was the statement that he gave immediately after his arrest in his initial trial. The statement about they beat my ass, I was just defending myself. They threatened him and just defending himself. But the evidence in this case, as Judge Marshall pointed out, was the physical evidence, which was 12 spent .22 shell casings that matched Mr. Kemp's rifle, 12 bullet wounds in the victims, that slugs that could be identified match Mr. Kemp's rifle. Every shot fired in the home was Mr. Kemp's. Every shot fired by Kemp found a living, breathing human being. There was no evidence of any other shot fired. The chamber of the .32 caliber semi-automatic pistol was empty. And Kemp's timeline, in his version that he gave to justify the shooting to Detective Ward, he says there was a rifle, and it makes it physically impossible for there not to be a rifle in Sonny Fegley's dead hands when he's killed. There's no evidence of anyone threatening Mr. Kemp with a rifle or a pistol. Kemp never mentions the pistol in either of his statements. And Cheryl Fegley was shot 5 times, twice in the back in the bedroom. There's no evidence of anyone, to use Kemp's term, that they beat his ass, and he doesn't mention it in the statement that he used where he was trying to justify this shooting. I'd be happy to entertain any questions regarding either of these issues. Let's see how much time I have.
Well, the state the argument I'd like for you to address is the idea of a cumulative prejudice that was building here in terms of, there's a long list of items that Ms. Vandiver brings to our attention, from Mr. Stuckey's criminal history being more serious than was actually presented to the jury, the lack of candor about Becky Mahoney's statements, on and on, that when you add all these things up, it's death by 1,000 cuts. And how do you address the cumulative nature of these potential errors?
Well, the two claims that they have added to, first off, with regard to the extra, more information about Bill Stuckey between the trials, the record before this court shows that Mr. Stuckey's testimony was almost identical to the testimony that he gave in the first trial. And if there's any question as to whether or not he was biased, or as I think Mr. Kemp points out, that he sugared his testimony by remembering the second time that Mr. Kemp said that when he shot Wayne Helton, he fell like a sack of taters. As we've pointed out, that's about the only difference in the two in the two particular versions. And to rebut that, any kind of claim of fabrication, one need only put on the first statement that he gave at the first trial. With regard to Becky Mahoney's statement, or the fact that Wayne Helton told her that he had showed her a pistol, we would admit that this information wasn't disclosed, but we would definitely dispute that it's characterized as Brady type material. It's not exculpatory or impeaching as to either sentencing or guilt. The prosecutor had both versions of Kemp's stories, and both made him the aggressor. What Wayne Helton said in his own home, out of the presence of Mr. Kemp, simply wasn't relevant to anything, because, as I said, Mr. Kemp's version of this never had a threat with a pistol as part of why he shot. And assuming that had been disclosed, the record here shows that Rebecca Mahoney did testify early in her cross-examination that she didn't hear some things because she was talking to Wayne Helton. She was never asked what she was talking about. And and there's probably good reason for that, because the last thing that that Mr. Rosenzweig would have wanted was some sort of explanation as to why Rebecca Mahoney was so terrified of Mr. Kemp. Mr. Rosenzweig had successfully at that point been able to keep out the fact that Mr. Kemp had once become enraged and broken Becky Mahoney's nose, or that he had shot at both Becky Mahoney and his mother, Lily Kemp. So when the jury heard both versions of this in the resentencing, no juror found that Mr. Kemp thought that he was acting in self-defense, as opposed to just
Mr. Holt, would you move on and address the argument about the non-disclosure of the evidence of the removal of the rifle from the trailer after the crime had been committed and time goes on? I think it was a girlfriend that may have been involved in retrieving a rifle.
There's no indication that the rifle, and curiously, the affidavit from the girl, the fiance who recovered a rifle from the premises, there's no indication in her affidavit that I assume was procured by Mr. Kemp's attorneys. It says where she found it. There are photographs of this, of the crime scene, of the dead body.
And why is that relevant? The placement of a potential rifle. Why is that relevant?
Well, because of the fluid nature of these events, by anyone's description, as I said before, the rifle would have been in the hands of Sonny Fegley. It wouldn't have been anywhere else. And this is sort of a smoke and mirrors sort of ploy by Mr. Kemp to suggest that there was another rifle involved in this. But the immediate crime scene, because Ms. Mahoney was still on the phone to 911 when the police arrived, there was no rifle to be found that was within the grasp of. It's reasonable to assume that if there had been a rifle within the grasp or within the reach of Sonny Fegley in this trailer, which was Wayne Helton's home, that the police would have recovered it there along, along with the pistol.
Well, even though Becky Mahoney remained on the phone with 911 until authorities arrived, that doesn't necessarily establish that she couldn't have also picked up a rifle and moved it away from the bodies or hidden it in a closet somewhere away from that immediate crime scene at the door.
Your Honor, I believe that is speculation that would not have been allowed in this case because there is nothing that ties, there is no physical evidence that ties a rifle to this crime scene, including the rifle, including all the photographs of what transpired, and more importantly, and what transpired vis-a-vis Mr. Kemp's versions, either the version that he gave blow by blow to Bill Stuckey, where he doesn't mention a rifle and he doesn't mention a pistol, or the version that he gave to justify what he did, in that he shot.
Mr. Holt, you have less than 2 minutes left, and I want you to also address the non-disclosure of Becky Mahoney's medical and psychiatric records. As you know, the prosecution was heavily involved in getting her treatment leading up to even during the trial. However, defense was not made aware of the depth of the involvement with the prosecution and Ms. Mahoney in this regard. How do you speak to that argument, as the state is saying that it's prejudicial and that Ms. Mahoney's testimony could have been more favorable because the prosecution was helping her seek mental health treatment?
Well, absolutely, the state was assisting her to receive mental health treatment, to receive medical treatment as well. But it did not have those records. Its victim witness unit was there to help a person who had witnessed the slaughter of 4 people. That particular, in putting on a prosecutor hat, it would have been very, I think that it would have been very favorable to the prosecution to show what the impact on Ms. Mahoney had actually been. But as Judge Marshall pointed out, Ms. Mahoney's testimony wasn't even necessary to prove that Mr. Kemp killed all of these people in cold blood. There was the physical evidence, including Cheryl Fegley shot in the back twice in the bedroom, as she told Bill Stuckey as she was crawling away and saying, "Please God, I don't want to die." And there was also the statement that he gave to Bill Stuckey that describing every second of every minute that happened in the home of Wayne Helton. To sum up, we believe that the claims before this court should have been presented in 2013 when they were discovered. This court should not surrender its role as the principal forum for deciding constitutional challenges to state court convictions. The claims, however, do not change the outcome of this case, because in any version of events given by Mr. Kemp, he left, armed himself, returned, and shot Wayne Helton and 3 other victims inside Wayne Helton's home, where he could not have been the aggressor. The state, on behalf of the victims and their families, respectfully request that this court deny Mr. Kemp's application.
Okay, thank you. The court will now recognize the petitioner for his rebuttal.
Thank you, Your Honor. The state concedes that this statement that Wayne planned to threaten Kemp with a gun was not disclosed in a death penalty case where the primary defense at the guilt phase and the penalty phase was self-defense. The court should look at the Brockwell case. The state suggests this evidence would not have been admissible. The Brockwell case says that this kind of statement goes to the res gestae of the offense. It goes to the state of mind between the parties, who was the aggressor, and whether the accused had a reason to believe that they were at risk of bodily harm. Those are factors that go straight to the heart of the guilt phase inquiry, but also to the moral judgment that the jury has to make. The state argues that Mr. Kemp was the aggressor under any version of events, and that's simply not true. He explained that he came back to see if, after driving around the block, not going home to get his gun, driving around the block to see if Becky would want to leave with him, and that when he did, there were people outside of the trailer that ganged up on him, threatened him, and showed a gun. The state discusses a supposed discrepancy regarding the pistol and a rifle. So when Mr. Kemp was explaining his story to Mr. Ward or Officer Ward, he said he was threatened with a gun. That was his word when he was asked what was happening. The officer said, what kind of gun it was it? He said, I have no idea. He said, was it a pistol? And that's when he said it was a rifle. And claim 2 really answers that supposed inconsistency. Could it have been that Mr. Kemp was answering this question about what kind, when he said, was it a pistol? It was a rifle with his own gun. That's a possibility. If he's saying he was threatened with a rifle, claim 2 is an answer to this that needs to be explored at a hearing. We have presented evidence also suppressed by the state that there was a complaint that someone was let in past the police tape and took a gun from the trailer. That person has signed a declaration saying, yes, I did remove a gun from the trailer and it was a rifle. That at least is sufficient to create that it's probably true, that this claim is probably true and warrants factual development in the circuit court. The state raised a couple of other issues showing why we need a hearing. Mr. Holt surmised that perhaps Mr. Rosenzweig would not have wanted this evidence in the trial. Well, I think that that's very unlikely, given it supported his defense at both guilt and penalty. But how this information would have been used at the guilt phase by the defense and the penalty phase, and what the response would have been, how that would have transformed the defense and the prosecution, is the perfect subject of a hearing. That is why the reinvestment procedure exists. How would this new information have changed the presentation at both guilt and penalty?
Counselor, can you square for me your self-defense claim with the fact that Mr. Kemp shot one of the victims twice in the back, an unarmed victim twice in the back?
Certainly his self-defense claim is, certainly his self-defense claim is better with regard to Mr. Helton and Mr. Fagley. And I'm not saying that the jury would have acquitted him of all 4 of these murders, but what I am saying is that this evidence undermined the premeditation element of capital murder. So in order for the jury to find him guilty of capital murder, they would have had to find that he shot all 4 people under the exercise of, a reasoning power, not in response to a sudden impulse. And the testimony is that it was, he shot off of his gun, and that killing Falls and Fagley was in response to this sudden impulse from a provocation.
And let me ask you also, or address something that Mr. Holt raised. What's the impact of the fact that this was Mr. Helton's home? And even if Mr. Helton did have a firearm available, there's no indication that firearm was ever discharged, but your client fired multiple shots at multiple people. But what impact? Mr. Holt seemed to stress the fact that this was Mr. Helton's home. And what does that do to the burden here?
One of the issues with regard to the self-defense instruction is that in order for Mr. Kemp to have had a duty to retreat, he would have only had to do so if he could do so in complete safety. And his statement has him being threatened at the door with a gun. And in order to leave, he would have had to turn his back on a person with a gun. I have to confess ignorance whether Mr. Helton had some elevated ability to defend his home. I'm not really sure how that interacts with Mr. Kemp's claim. I think the more important fact is how it operates on Mr. Kemp's mindset and whether or not it helps prove mitigating circumstances. And can you remind me what the second part of your question was?
No. I think you've covered it. Thank you.
Okay. And if there's no,
I see that your time's expired. Are there any other additional questions for the court? Okay, Ms. Vander, that'll complete the rebuttal argument. Thank you. Thank you for both counsels. Then that'll complete our oral argument today. Court will conduct a case conference on this case at 11 o'clock or shortly thereafter. Otherwise, the court will be adjourned for today. Thank you.
Thank you, Your Honor.
thank you.